And Your Excellencies and dear colleagues, good afternoon. Thanks to the organizers of the webinar for inviting me. I've had the opportunity over the years to work in many countries in both criminal justice and juvenile justice reform, and I would like to share with you a few things I think I've learned about the experience of these countries in trying to implement non-custodial alternatives. I will not name the countries. I understand why countries like to advertise and celebrate their success, but they're much less eager to talk about their failures or the challenges that they face. I respect that, and therefore my comments will be of a more general nature. Forgive me if at times I appear to be excessively generalizing. Let me first start by saying that without a whole system approach to justice reforms, attempts to implement alternatives to imprisonment have a very low likelihood of success. Having made that clear, I can perhaps focus on four implementation aspects that, in my view, deserve special attention. First one, of course, is legislation. We've said, other speakers have said something about it, but I'll add a few comments. The second one is judicial decisions and sentencing decisions. Third one is about the infrastructure necessary to fully implement alternatives. And the fourth one is talking about how systems deal with non-compliance with court orders when alternative sentences are used. So starting with legislation, I'd say that legislative amendments may sometimes be a good starting point, but they're not an end goal. To some extent, the same is true of official policy statements, unaccompanied, as they often are, by effective implementation measures. Keep in mind that in many countries, legislation enabling the use of alternatives exists, but is more or less dormant. There is the illusion of compliance with international standards, but little has actually changed in reality. Keep in mind also that penal law typically only authorizes alternative measures and rarely mandates or prescribes them. On the other hand, it mandates and prescribes imprisonment. Criminal law of most countries defines the relative seriousness of criminal offense in terms of the number of years of imprisonment the perpetrator of that offense is exposed to. In fact, even international conventions use the same yardstick to define the seriousness of various offenses or to encourage state parties to treat a certain type of crime more seriously. It makes it hard, therefore, to move away from the position that imprisonment is the standard by which other measures are to be judged. Some countries, like mine, have included an official statement of sentencing principles in their penal code, stating, for example, that imprisonment should be used as a measure of last resort, or that alternatives should always be considered, and so on and so forth. But these general statements seem to have had a limited effect, particularly since they usually must be applied and balanced against other sentencing principles. It is possible, however, to engineer a drastic change in the use of imprisonment for certain types of offenses when the law actually prescribes a response other than imprisonment, and when imprisonment becomes the decision that actually needs to be justified on a case-by-case basis. I'm referring here, for instance, to the example of the Canadian Youth Criminal Justice Act, which led to a drastic decrease in the number of imprisoned youth in my province from about 3,000 to about 70 uh, by mandating the use of alternative measures. So let's be realistic here, however. When we're talking about alternative sanctions, we're not talking about alternatives to life imprisonment, and sometimes we forget to explain that to the public. We're essentially talking about alternatives to short-term imprisonment. And as other speakers have mentioned, we know that short-term imprisonment serves very little useful purpose, and it is in fact very criminogenic. It contributes to crime. It doesn't prevent crime. Some countries, and we've just heard that France has done so, Scotland is another example. Some countries have introduced a presumption against short-term imprisonment in their penal law. Others are considering establishing a presumption in favor of diversion for various types of offenses. So far, in all of those countries that have gone in that direction, there does not seem to have been any negative public safety outcome as a result of those bold decisions. That takes me to a second point about courts and judges. We tend to make the implementation of alternative measures a court and judges issue or a sentencing issue. Oftentimes, technical assistance projects are focused on judicial decision-making. We tend, therefore, to focus a lot, and perhaps too much, of our attention on the judges and the decisions they make. Of course, these decisions are important. But when we do so, when we focus exclusively on the role of judges, we really fail to appreciate the fact that we're dealing with a systemic challenge, not just a judicial decision-making issue. In my experiences, in different countries, different types of systems, judges will normally use credible measures if these measures are indeed available to them and if they are aware of these possibilities. At first, judges may be cautious, but they quickly see the advantages of a different approach. The opposition, in my experience, and of course it's hard to generalize, rarely comes from the judges. It comes from other parts of the system and sometimes also from the public. At the same time, the greater use of alternative measures at different levels of the criminal justice system, for example, through diversion, can free the courts of cases that can be better dealt with elsewhere and reduce case backlogs in court. And of course, judges appreciate that and benefit from that. In Canada and many other countries, the experience of problem-solving courts, drug courts, indigenous courts, family violence courts, mostly in common law countries, I should say, clearly shows that judges are willing to play an active role in shaping and monitoring non-carceral responses to criminal behavior. However, as other speakers have already noted, it is necessary to make sure that the right information is brought to the attention of the court at the time of sentencing. This highlights the importance of pre-sentence or social inquiry reports, or different names, but basically means of bringing the information to the attention of the judge, but not just about the offender and the circumstances concerning the offender, but also about the alternatives that are available in that particular case. This is all true, but I would like to add here one other thing, which oftentimes is neglected in implementing alternative measures, is the need to bring feedback to the courts. I see that our chair today is constantly reminding people of, please provide us with statistics. Well, it's because we're all hungry for those, in particular judges. Judges are making very important decisions and get very little feedback on the impact of their decisions. They don't have access to tailor-made reports on what happens following their decisions. In most systems, judges make a decision about the offender and then hope for the best, don't really know whether the decisions were the best ones or not. So they need that kind of feedback, and there are very few systems that actually provide judges with that kind of information on a regular basis. Here also, one last point I would say about the implementation of this at the court level is the experience of COVID-19. Most countries have had to limit their use of pretrial detention and find some viable alternatives. They've actually and some of them were resistant to that, but basically, as we say, necessity is the mother of invention, and people had to adapt to the circumstances created by the pandemic. And they've actually proved that it was possible to use alternative measures in areas where people were hesitant to do so beforehand. And that was the same thing also for diversion, which out of necessity was sometimes used more extensively during the pandemic. The other element is infrastructure. Uh, Vivian Chin earlier talked about the importance of a good, healthy probation service or equivalent, community corrections, whatever the name is. It's important to understand that without a functioning agency or institution to see to the implementation of those measures, they will soon lose their credibility. In my experience, sentencing reform projects often rely too much on training and awareness raising or on official policy statements, and not enough on actually building the program infrastructure that is required. There's nothing like a healthy, well-resourced, and competent probation service or community-based correction service to move the whole system forward. Building such a system often encounters questions about transferring of resources from other sectors, sometimes transferring resources from institutional corrections, from prisons. We obviously cannot ignore the high transaction costs of these institutional adjustments that we're discussing today, and they require attention. These are not the kind of things that happen by themselves unless if we are not planning them. Very often, alternative measures are not seen as credible or accepted by the public, and we all know this. So we blame the public instead of making a conscious effort to build the credibility of these different approaches to crime prevention and to the prevention of recidivism. We dream of public information campaigns, but know in advance that they will not be sufficient to fundamentally change public attitudes. We have a bit of a problem with how we think about building that credibility and building community support. I will just add a comment about the presentation made by Anna Giudici earlier about the role of police. We forget sometimes that the part of the justice system which is in most direct contact with the population on a day-to-day basis, and also in direct contact with the media in most countries, is the police. And the police have a huge role in either supporting and explaining to the population what we're trying to do with community measures, or actually denigrating those measures. And I won't name countries, but I know, and I've been involved in at least 3 of them, where major efforts to implement alternative measures have largely failed, in part because of sabotage and the attitude of police leaders who actively try to militate against the implementation of those measures. Now, I'm not generalizing to all police forces, but keep in mind that if you want the public to understand what is being achieved with those alternative measures, your loudspeaker is usually law enforcement and at the community level. So this is all the more important, as Anna said earlier, to bring them on board. Finally, a few quick comments about non-compliance. We haven't talked a whole lot about this, although one of our 2 speakers have mentioned it. But in implementing the resources, the community alternatives, we got to be aware of the fact that it will not work all the time, that many offenders will not comply with the conditions imposed by the court, and that we will have to take measures. And very often, this aspect of community supervision or supervision of community-based sentences is not getting the attention that it deserves. Probation officers, police officers, and others who will intervene in cases of non-compliance have not been properly trained. And of course, they're risk averse and they don't want to be blamed, and therefore respond oftentimes inappropriately to small issues of non-compliance. So I think this is an important part in implementing, and we need to pay more attention to what we do in cases where offenders, I'm not talking here about committing new crimes, but are not complying perfectly or to our satisfaction with the conditions ordered by the court. Finally, on this non-compliance issue, I would say everyone today has been talking about first chance, second chance, give people a second chance, and we fall into that trap. We forget that the desistance from crime is a process, not a single event. So we need to start talking about third chance and fourth chance and fifth chance, because the reality of many of those offenders, particularly those with mental health issues, addiction issues, and so on, is that they will not necessarily respond well the first time around to community alternatives, or if they do, it will not have necessarily all the desired effect in terms of preventing recidivism. So we should not close the door to the wider use of alternative measures. I know that we normally, when we start a new alternative measures program, to pacify the public and to try to minimize the perceived risk, we tend to say to limit those alternatives to youth or to first-time offender. But at some point, we need to expand that and understand the value of alternative measures, even for people who've had their second chance already, but are still struggling with issues that they cannot cope with. And I will conclude here, but just not before I remind everyone that it's very, very important to put in place the right monitoring and evaluation mechanism. It's crucial to do this for so many reasons, but including also to report back to the population, to demonstrate that those measures have a successful impact, and to show that they do not have a detrimental impact in terms of public safety. So I will stop on this, and thank you very much, Mr. Chair.